think we're live. This is the first of what is very likely to be many videos that will come out intermittently on the current administration, current events, court decisions of interest, basically anything I feel like ranting about that I think might be of interest to someone else. This particular video is, as it says up there, about the Ninth Circuit hearing on the temporary restraining order issued by Judge Robart. As a precursor, I'm speaking just for myself. These are personal observations that have been informed by various sources online, as well as my own listening of the hearing itself. This in no way reflects the opinions, beliefs, etc. of any other individual, business, entity, corporation, branch of any sort of government, foreign entity, regardless. This is just me ranting. So take anything I say with a grain of salt. Anything I reference that requires a citation, that'll be in the links below for every video. As well as if you missed the hearing yourself, that link's down there too. You should definitely listen to it if you get a chance. It's basically law porn meets debate porn. It was a lot of fun to listen to. And honestly, because it's on a subject that people are actually interested in, it's a good way to kind of get a glimpse of how these court proceedings usually work if this is not something that you would usually spend an hour doing. That said, if an hour-long video of a court hearing sounds like pulling teeth, this video will hopefully be a little bit shorter than that. So I'm going to jump right in. This is basically the case of Washington and Minnesota et al. Versus Trump et al. This was a legality hearing on the temporary restraining order that was issued on Friday. Federal Judge James Robart, he's part of the U.S. District Court for the Western District of Washington State. He suspended key points of Trump's immigration ban, his now infamous executive order that addressed Muslims coming in from 7 different countries into the U.S. It caused nationwide chaos in its implementation, and there's a lot of questions about its legality and constitutionality in the aftermath. Trump, of course, as soon as he found out about the judge's ruling, immediately grabbed himself by the Twitter and started tweeting out about why this so-called judge, and that's his words, not mine, should be allowed to stay a executive order, essentially. The president is given generally a lot of leeway when it comes to matters of foreign safety and foreign entities, and so it was unusual in his eyes for a court to grant a temporary restraining order that applied nationwide. As you can likely anticipate, calling the judge a so-called judge is not the best approach if you're then going to be appealing that decision to a 3-judge panel of other so-called judges, especially when 2 of those were appointed by Democratic presidents. As far as who's who in this proceeding, you're going to hear the name Noah Purcell. He's the Washington State Solicitor General. He represented the states of Washington and Minnesota who filed the lawsuit in Seattle that resulted in the federal district judge's decision that's now up for review. It was also Purcell's idea to solicit all the tech companies that ended up coming in as amicus briefs. Don't put too much credit behind those companies. They're, like everybody right now, acting in their own self-interest. They get a bunch of free press looking liberal and against Trump without actually having to put much money where their mouths are. On the other side in front of the circuit was poor August Flenge. He's a career trial attorney in the Department of Justice's Civil Division. And he was brought in to represent the Trump administration pretty much hours before this argument went live. He was kind of called in the 11th hour. This is not his law, his area of expertise law-wise. There was no evidence in the record for him to refer to. So he was kind of hung out to dry a little bit. We mostly feel really bad for this poor guy, August Flenge. The court itself is a 3-judge panel. We saw Judge William Canby Jr., who is a Carter appointment, so another Democratic appointment. Judge Michelle Friedland, Obama appointment, and Judge Richard Clifton, who is a Bush appointment. And we will see that kind of echo through this hearing, since for sure Clifton gave Purcell the most of the hard time that we saw from the judges, whereas all 3 of them were taking pot shots regularly at poor Flenge. So the issue in this case, it does not decide whether the ban is legal or illegal. I've seen that mistake a few times online, even in some of the news articles, there's no way for a case requiring this amount of detail, fact, and evidence to have already made it to the Ninth Circuit. What's being argued is whether Robart's temporary restraining order, which is currently blocking enforcement of President Trump's immigration order nationally, can stand for a little while longer while both sides prepare evidence for a more detailed hearing back at the state level. So it reached the Ninth Circuit as part of its emergency hearing schedule or docket. And if the temporary restraining order, or TRO, is left in place and it is returned to the state, this case will end up actually back in front of the so-called Judge Robart, who issued the TRO to begin with. So I imagine that judge not going to be super happy with Trump when this trickles back down. It'll be interesting to see how he conducts himself. So as far as the hearing goes, Flengy went first, both arguing that the ban was keeping the U.S. safe and that the plaintiffs, which are the states of Washington and Minnesota, didn't have standing to challenge the president's action because the executive order was well within the president's power, his words. A standing is a legal issue. It basically requires a harm that you can elucidate somehow, that you can talk about, you can point to it and say, this is how I was hurt, that lets you come before a court. It prevents people from bringing basically hundreds of thousands of suits, but it prevents people from bringing suits when nothing's actually been done to hurt them personally in any way. And it prevents profiteering off of other people's hardness and kind of like things going wrong. So Flengy's argument, though, led to a very skeptical question from Michelle Friedland, because she basically asked, well, are you arguing then that the president's decision in this regard is completely unreviewable? Flengy is quiet for literally 5 whole seconds during the hearing, and then kind of shoots himself with a shotgun in the foot by saying yes, and then going on to kind of try and fail to tightrope walk between claiming that the president is due essentially unquestionable deference on an issue that's impacting foreign individuals and national security, but then very carefully suggesting that there are some constitutional limitations on what the president does that allow for review. And that those things, whatever they are, and he never gets them, and that when the court asks him what they are, he can't give any, but that those things that allow for review just aren't present in this case. And again, the court continually asked him to name one, and he just kind of couldn't. There was also discussion about Trump's intentions with the ban. There was a great deal of evidence, and this is a surprise to no one who's probably watching this video since we're the ones who are paying attention. There should be no surprise that people think that this ban has to do with a lot of active animus on Trump's part toward Muslims, that this is a religiously targeted ban. And that was a driving reason for the ban, that any true on-the-ground evidence of security issues with respect to their entry to the U.S. just isn't present. When asked what evidence Flengy would provide back at the district level once the case is returned that would counter this appearance of bias, Flengy basically said he had none. That at this time, he said that the case, he kept saying the case was happening very quickly. And he's totally right, especially since Trump pulled this poor sod in basically hours before this hearing. But there's no evidence that he could provide. And he basically just said that the court shouldn't put too much weight on the fact that Trump said a lot of stuff while campaigning. So don't put a lot of weight on these crazy things he said to try and drum up votes. Problem is, we've basically seen him follow through on almost every one of his crazy claims while campaigning. I don't think there's any reason the court couldn't hold him accountable for things he said on the campaign trail. He's made a fantastic record, if it can be called fantastic, maybe awe-inspiring is better, of following through on all the things he said he would do, even the horrible ones. But again, we see Flengy arguing that Trump's order merely puts a temporary pause on entry from these 7 countries until security concerns can be reviewed. He says this is completely normal, that they just want time to see what these vetting processes are and whether they're doing what they're supposed to. That it's not a ban, and it's definitely not a Muslim ban, which would be intended with animus against a religious minority. They very briefly discussed the cases of Mandel and Din. They were referred to a couple of times about standing. I'm going to include links to those cases below. It's tangential and long, and I'm not going to cover it here, but in essence, Flengy was claiming that these cases show an appropriate approach to how an individual could achieve standing, since the court continuously seemed to suggest, as did Purcell, that if the states could not have standing on behalf of their residents, it's not clear who would, except for an individual who is of Muslim descent and was trying to interact with a family member, and there's an enormous barrier for them to enter our court system. And it should be fair that states then represent these people if there are enough of their constituents that were affected. So now Purcell comes in, and he opens by saying that it's the judiciary's role to check abuses by the executive branch. That is accurate. We have a 3-part justice system. We have the executive branch, we have the legislative branch, and we have the executive. And the judicial is supposed to govern the laws made by Congress and our executive branch, and the actions taken by our president and other executive officers in the executive branch. And vice versa. The executive gets to look at what the laws are being made by Congress, and he has a veto power if he thinks it's unfair. And vice versa. So everyone's tangled in each other and making sure that no one's doing anything incredibly stupid. Right now, what is scariest for us as people living in this nation is we have watched an executive branch start doing things that no one knows how to stop. The courts don't know what to do. they have to wait for someone to have standing. And this is one of the first times we've really seen the courts taking a bite at something that the president's been done, which might be why we see these judges so eager to act, as this is something that they do feel does have standing, that they can act upon. Sorry, pings in the background. We also see a Congress that does not know what to do, because the president is increasingly showing he's not really a Republican. He's just doing the things he said he would do on the campaign trail. So Congress doesn't really know what to do. The president just keeps acting, and no one seems to know how to stop it. So Purcell has opened by saying it is the judiciary's role to check these types of abuses by the executive branch. I'm going to quote him here, so I'm going to go ahead and read this. But he said, but the president is asking this court to abdicate that role here, to reinstate an executive order without meaningful judicial review, and to throw this country back into chaos. That's beautiful. In my opinion, he hit a home run right off the bat. He clearly explained a lot of the fears that I and many, many others by now have written at length and ad nauseum, as well as appealing to thoughts about the kind of insidious nature of what these types of claims, that a president's executive order can't be reviewed, would actually mean for our republic. That's scary. The idea that the president can do things and there's no check just because he's the president, and this is an area of deference, is a really dangerous precedent to set. So Purcell also had his cagey moments, though, particularly, as I said, questioning from Clifton, our Republican judge on the bench, as to whether or not the order was narrowly tailored enough and potentially in the national security interests so as not to be considered a, quote, Muslim ban. Clifton said more than once that he was not necessarily convinced that this was a, quote, Muslim ban, because the 7 countries encompassed were only a small percentage of Muslims in the world, and the vast majority of them weren't affected as residents of those nations by this ban. Purcell countered very quickly and, in my opinion, correctly, that to prove religious discrimination, the states don't have to prove that it harms only Muslims, or even that it harms every Muslim. It's sufficient that it is intended to harm Muslims because they are Muslim. And again, we see a lot of evidence in the wings that Flengy keeps saying that the court should ignore, that Trump really was trying to target a specific religion. It had nothing to do with terrorist concerns. It didn't really have to do with the fact this is a list of countries identified in the Obama administration. It's about their religion. Clifton didn't really let go of that bone for a while, though, and he did insinuate that he thought the temporary restraining order, the TRO, might have been overbroad, since it denied the president the right to restrict travel, even for people in those 7 countries who had never been to the U.S., they don't hold visas, they don't have family ties here. That said, it's not clear how the TRO should have been tailored to avoid that. And Judge Friedland actually kind of came to Purcell's rescue here, and he reminded the attorney that he had come with exhibits speaking to this point. As an aside, from all the oral arguments I've ever seen, it's decently unusual for a judge to assist an attorney like that, save in situations, and I think this is one of them, where the overall appearance and the result of the court's decision is of the highest importance. It seemed a little bit like Friedman was showing her hand and trying to keep Purcell on track here. The judge didn't seem to want him to flounder the way that we had seen Flengy really floundering throughout this particular part of the hearing. Again, briefly as to the standing issue, which is, again, the harm to an affected party that gives them the right to bring suit, Purcell claimed the order had harmed his state's residents by splitting up families, holding up students trying to travel here to study, and preventing people from visiting their families abroad. He said that it affected thousands of Washington state residents. Clifton, again, said he suspected that was only a very small fraction of the state's residents, but again, it should be enough here, I believe, to have admitted them to have standing. In his closing statements, Flengy, perhaps sensing that the court was leaning away from the administration's position, kind of tried to argue for a compromise, which was pretty interesting to hear. He seemed to be playing off the things he had heard Judge Clifton saying about the extent and the overreach of the TRO. And so he said that if the TRO and the president's travel ban was too broad, if that's what the judges decided, that the judges should then limit that TRO to state residents who plan to travel or who plan to return to the country and eliminate its reach beyond U.S. borders. It seems unlikely the Ninth Circuit will do much more than return the case for deliberations at the district court. They're not probably going to take Flengy up on that offer, but it was interesting to see him try and essentially compromise with the court once he got that nuance that maybe the judges weren't buying what he was selling.